Good morning, everyone. It is 9:30. Welcome back to this water right change petition hearing for the California WaterFix project. I am Tam Doe-Duck, board member and co-hearing officer. Chair Marcus, and also co-hearing officer, is on a plane at the moment, but she definitely will be viewing the videos for today. And on my right is board member Didi Diamo. To my left, Andrew Derringer and Jean McHugh will be assisted today by Ms. Galen. Since I do see some new faces, please take a moment and identify the exit closest to you. In the event of an emergency, an alarm will sound, lights will flash. We will evacuate, preferably using that door, because that door will lead you to the stairway, which we will take down to the first floor and meet up in the park across the street. If you're not able to use the stairs, there will be security and safety monitors wearing fluorescent color vests and caps, and flag down one of them, and they will direct you to a protective area. Secondly, this hearing is being recorded and webcast, so please speak into the microphone after pushing the push button and making sure that the green light is lit, and begin by stating your name and affiliation, if necessary, for the court reporter, who is back with us for the third day in a row. Thank you, Candace. And third, and most importantly, please take a moment and put all your noise-making devices to silent, vibrate, do not disturb, airplane mode. All right. Are there any housekeeping matters that we need to address at this time? I believe the only one that I will ask Mr. Jackson to respond to before we get to his witnesses is Mr. Mizell had a question with respect to Dr. Budgore's testimony yesterday. Are you able to provide an answer?
I'm actually not sure which question.
Mr. Mizell, during cross-examination of Dr. Budgore, you asked for, I believe it was a reference or a citation to something in his testimony.
Yes, that's correct. It would be a citation for the underlying source of data on the conclusion about the economics of water in the Santa Barbara region. Dr. Budgore described how as costs go up, the demand for water decreases. And yet we had not been able to find data in the record that was supportive of that assertion. So that's the citation that I was requesting yesterday.
I believe it's in Appendix 5 to the Santa Barbara report.
And is there a particular section you're aware of?
No, I didn't find. I didn't find the section. That's just what he told me.
In addition, I think Dr. Budgore would probably be relying on his experience in these matters, as well as whatever citations he had.
And I think that's what the general managers of each of the districts that he talked to told him.
Mr. Mizell, it seems like that's the only response you're going to get.
Very well, then I'll lodge an objection for the record on hearsay to the extent that he relied on the statements of the district managers from that region.
We will so note the objection on hearsay grounds.
Thank you.
Right.
When it's convenient, I have one housekeeping request.
Go ahead.
Have you determined whether or not there will be a date for filing objections to cross-examination exhibits?
Yes, I will get to that at the conclusion of today.
Thank you.
All right. At this time, I welcome Mr. Smith back. Thank you for coming back. And welcome former Vice Chair Del Piero. If you would both please stand and raise your right hands. Do you swear or affirm that the testimony you're about to give is the truth? Yes, I do. Thank you. Please be seated, and I will ask your attorneys to proceed with direct testimony.
Mr. Smith, is CSPA 210 a true and correct copy of your testimony in this matter?
Yes.
Is CSPA 211 a true and correct copy of your statement of qualifications
Yes.
in this matter? Could you please summarize your testimony, sir?
I'd like to make a few points. Starting out, I see the public trust doctrine as a background principle extending back to the days of the Roman Empire. In 1853, the California court said that the use of water is a usufruct right. That means, in simple terms, you can use it but don't abuse it. In 1897, the Truckee court said that's when we learned that fish were a very interesting piece of property owned by the people, managed by the state. Let's jump ahead now to 1971 and look at Marks versus Whitney. The location is Tamales Bay. It's a small estuarine area on the California coast. It has a tideland, it's tidal water. It has a small stream, Lagunitas Creek, which has a small run of coho, salmon, and steelhead trout. The court said that the public trust is more than traditional uses of navigation, fishery, and commerce. It includes the preservation of those lands in their natural state so they may serve as ecological units for scientific study, as open space, as environments which provide food and habitat for fish and for birds, fish, and marine life that favorably influence the scenery and climate of the area. The ecological components of the Tamales Bay estuary are not much different from the very large San Francisco Bay Delta. To this biologist, the broadening understanding of tidal waters and marshlands would encompass all the aquatic and adjacent ecosystems. This would easily fit the Bay Delta and the tributary systems. It easily fits rivers and streams in their beds and associated riverine systems, habitats, and riparian corridors. This broad definition easily fits lakes and similar water bodies like Mono Lake. In 1980, I was with the Fish and Wildlife Service. I stated in the paper that if the public trust is forcefully applied to the allocation of water and water rights, it could result in the board placing restrictions on water rights. For example, the state board would not be able to approve such appropriation which harm or degrade the public rights in fish and in-stream flows. The state board could just say no to that water applicant based on protecting the public trust. At the Mono Lake Basin, the state board did a very good job in protecting Mono Lake and the tributaries. But it's going to take vigilance on behalf of the people, in this particular case, Mono Lake Committee and others, to make sure follow-up studies are done and corrective actions taken and monitored. The Adolph Moskowitz was the lead attorney for LA Water and Power. In 1994, he made a presentation to the Water Forum. He said simply, any trier of facts is required to balance and accommodate all legitimate competing uses of a water body. But he also stated, the importance of the public trust doctrine cannot be diluted by treating it as another beneficial use under Article 10, Section 2, co-equal with irrigation, power production, and municipal water supply. He goes on to say, the public trust doctrine occupies an exalted position in any judicial or administrative determination of water use. If harm to public assets, uses, and values is projected to be significant, and it, in my opinion, it doesn't take much, then the beneficial use may have to cut back or eliminate it. Again, the state board could just say no, or can restrict or limit the use of water to protect the public trust. Recent courts have already said as much. The allocation of rivers in the Central Valley are greatly oversubscribed. The board's priority is to protect public trust whenever possible. Audubon Court said the public trust protection is an obligation and affirmative duty of this board. Physical solutions may have to be adopted to mitigate measures and install measures before the project can move forward. In other words, build them first. This may result in retrofits to existing projects before others can move forward, or mitigation be taken now to protect damage in the future. For example, there are about 379,000 acres of drainage-impaired lands in the San Luis unit of the CVB. The application of water to such drainage-impaired lands, with its attendant incidental losses and degradation to water quality, could easily constitute an unreasonable use of water. The selenium deformed bird drainage issue at Kesterson in 1983 is still fresh in my mind. And that 1983 date, when we found those birds, was only about 3 months after the Mono Lake decision came down by the California court. This really drove home the need of protecting the public trust. Today, the spring run in the Central Valley is extinct in the San Joaquin and a remnant run in the Sacramento Valley. The winter run is a shadow of its former self, and based on my information from the Pacific Marine Fishery Council, there were 490 adult winter run and 485 jacks in the 2017 run. Not a good showing for fishes that are supposed to be protected under the public trust. Late fall Chinook is not doing well either, but it has about 4,400 adults in the run, and it's a species of concern. The fall run, last year's run that came in, was 44,547 based on information from the Pacific Marine Fisheries Commission. The expected escapement for sustainable fishery is 122,000. We kind of blew it there, didn't we? Something's wrong. The longfin smelt is listed as state threatened. The delta smelt may even be a possible extinction, a footnote to our water use and development history. Extinction of an aquatic species should not be a management option. Under the public trust doctrine, members of the public, present and future generations, have a clear property right to clean water, clean air, healthy and uncontaminated fish and wildlife species, and resources having many public trust values. The public trust doctrine as a background principle is supreme to and supersedes the private use rights of an individual or corporation that may have the same property right use. Until regulatory agencies believe that the people's property and trust rights exist and act accordingly, there will be little meaningful action taken to protect the public trust, associated resources, and values. The public trust may still end up being the courts, and the courts being the final adjudicator. Thank you.
Thank you, Mr. Smith.
Good morning. Tom Keeling for the San Joaquin County Protestants, and for the record, Mr. Mark Del Piero will be appearing today and testifying on behalf of San Joaquin County Protestants, the Sea Spa, Seawind, Aqua Alliance parties, and land, local agencies of the North Delta. So that's why Mr. Jackson, Ms. Meserve, and I are all here today. Good morning, Mr. Del Piero.
Good morning, Mr. Keeling.
Thank you.
I'm sorry, Mr. Killing, before you continue, I just want to make everyone aware that an alarm has sounded on another floor. We are in the midst of evacuation drills, so we are going to wait for an announcement to come overhead. Chances are very good that other floors, not ours, are being evacuated, so don't be alarmed. It is going to be somewhat annoying because it'll keep going off in the background.
Yes.
I will try to speak loudly.
Attention all building occupants. Attention all building occupants. An alarm has sounded on floors 20, 21, 22. We are in the process of investigating the alarm. Floors 20, 21, 22. Please continue with your relocation procedures. All the floors, please wait for an upcoming announcement. I repeat, attention all building occupants. An alarm has sounded on floors 20, 21, 22. We are in the process of investigating the alarm. Floors 20, 21, 22. Please continue with your relocation procedures. All the floors wait for an upcoming announcement.
Right, I think it is safe to proceed, Mr. Keeling.
Thank you very much. Mr. Del Piero, is Exhibit CSPA 208 corrected a true and correct copy of your Part 2 written testimony?
It is.
Did you write that testimony?
I did.
Is Exhibit CSPA 209 a true and correct copy of your statement of qualifications?
It is.
Mr. Del Piero, could you please summarize for the hearing officers your written testimony?
Thank you very much. Hearing Officer Doduk, Board Member Diadamo, and Hearing Officer Marcus, who I understand is listening to us from the other end of the electronic spectrum. It's a pleasure to be here today. I want to apologize because, as the hearing officer knows, today's the first day that anybody's seen me outside of a hospital bed, and so my voice is a little rough because of the surgery. I will apologize, and it may take me a little longer than normal, but we'll do the best to muddle through. My written testimony has been previously submitted to the board, and I hereby affirm that it is my own, written by me, without the assistance of any third parties. The core of the public trust doctrine is the state's authority as sovereign to exercise a continuous supervision and control over the navigable waters of the state and the lands underlying those waters. This authority applies to the waters tributary to the Delta and bars petitioners, or for that matter any other party, from claiming a vested right to divert waters once it becomes clear that such diversions harm the interests protected by the public trust. I will go on to say later that I believe that public trust is the preeminent beneficial use under both the Constitution and the laws of the state of California. The fact that these diversions of Delta water by petitioners to points south of the Delta over the past 50 years, the fact is that those diversions have not just harmed but decimated the public trust resources currently in the Delta. Finally, the massive loss of public trust resources in the Delta during this time cannot in any way be construed as being in the public's interest. And the continuation of this devastation to the public trust and the public trust resources within the Delta by the petitioners will not benefit the public in any manner in the future. The water rights enjoyed by the petitioners were granted, the diversions were commenced, and the diversions have continued to the present without any consideration of the impact upon the public trust. The state, specifically the State Water Resources Control Board, and other state agencies, including petitioner DWR, have not at this point attempted, let alone met, the mandates articulated in the Audubon decision that, I quote, before state agencies approve water diversions, and parenthetically, I would include changes in points of diversion, in my opinion, are encompassed in water diversions as defined by Audubon. They should consider the effect of such diversions upon interests protected by the public trust and attempt, so far as feasible, to avoid and minimize any harm to those interests. I believe that this failure is evidence of the petitioner's acknowledgement of the lack of any additional available wet water in the Delta system. The only so-called water that remains is on paper and does not exist, except in the wettest of years, wherein a lack of both storage and demand renders it of little consequence for domestic consumption. This is inherently the problem with the California WaterFix as it's been characterized, and it is a problem with this process since the watered-down versions of D1641 were adopted nearly 2 decades ago. Absent the State Water Resources Control Board, prior quantification of the constitutionally mandated and required public trust flows necessary to protect and preserve public trust resources in the Delta, and the prior allocation of those flows to public trust purposes by the State Water Resources Control Board, the petitioner's CWF will result in an unreasonable and, in my opinion, hence unconstitutional use of the state's waters. The failure by the State Water Resources Control Board to take action over the past 18 years to prepare and forcefully implement with measurable, significant, and enforceable penalties for noncompliance a comprehensive analysis of the required water and flows to protect the public trust resources cannot be construed as having satisfied the State Board's standards, nor can it be construed as having satisfied the constitutional duties of the State Board as articulated in Audubon and in the Racanelli decision. The absence of even an effort at the preparation of a detailed, evidentiary-based water availability analysis underscores why current error-ridden problems in the CWF process of piecemealing its environmental reviews of their ever-changing project is as massively broken as the public trust resources in the Sacramento-San Joaquin Delta. Failure to cause the preparation of a WAA in light of the unrefuted evidence of massive species loss and decline due to the lack of water availability constitutes an admission that the state has erroneously overcommitted, on paper at least, the available water resources of the Delta. I participated in most of the evidentiary hearings leading up to the adoption of the State Water Resources Control Board Decision 1641 back in 2000. Prior to all of the hearings that took place prior to the end of my tenure on April 1st, 1999. D1641 was intended to effectively implement the Water Quality Plan objectives of 1995. Unfortunately, it has been a failure. The teeth in D1641 were effectively knocked out when it was subsequently adopted in the year 2000. And those objectives that we anticipated would ultimately be implemented as part of a subsequent decision when we adopted the Water Quality Plan in 1995 have not been realized or achieved. That decision has failed to provide adequate Delta outflow to the San Francisco Bay. It has failed to protect, preserve, or even quantify the Delta Public Trust resources and Delta Public Trust protected fisheries. That decision has failed to obligate major water rights holders to actually meet or exceed all of the water quality standards that the board adopted to guarantee the sustained health of the estuary and its public trust resources. It has failed to elevate the protection of the state's public trust resources to a higher level than other common beneficial uses, thereby ignoring the constitutional imperatives to do so that have been articulated in both the Audubon and the Racanelli decisions. It has failed to guarantee equivalency for the protection of environmental resources as against the needs and continuing ever-increasing demands of export contractors. Moreover, the petitioners have effectively ignored D 1641 when strict compliance with its mandates became inconvenient due to the export demands on the projects. Petitioners' assurances to the State Board that they will comply with the water quality standards in the revised 2006 Water Quality Plan update if their projects are only approved lack sincerity, intellectual honesty, and a successful track record upon which they can rely and point to satisfy the requirements and demands of the State Board for enforcement. It is clear now that precise, detailed, and measurably enforceable terms amended into the petitioner's permits with financially and significantly punitive penalties for violations by the petitioners and their customers are the only way to stop the petitioner's periodic and errant violations of water quality standards and of the senior water rights of other innocent parties in the Delta and that serve Delta communities generally. And just parenthetically, I would ask that the board seriously consider, in regards to those comments, the board's adopted findings that I know the chair and the board members worked so hard on during 2010 on the water quality plan policies. If you want to find the conditions, the measurable, enforceable conditions to incorporate into the permits that the petitioners are asking for, look to your own plan that you adopted in 2010. But make sure they've got teeth so that you don't have to continue to come back repeatedly for innumerable hearings to try and enforce what we all know should be enforced by the petitioners themselves.
Mr. Del Piero, perhaps a clarification.
Yes, ma'am.
It was not a water quality control plan that we adopted in 2010.
No, it's the policies that you adopted in 2010.
It was the flow criteria.
The flow criteria, yes,
that you're
ma'am. That's what I'm
referring
referring to.
Thank you.
The WaterFix and its tunnels are proposed by petitioners as new enhanced conveyance mechanisms to take water across the Delta for increased reliability. As has been disclosed previously, these new pipes do not impound or store any more water than is already present in the collapsing ecosystem of the Sacramento-San Joaquin Delta. The dual tunnels do not create any new water resources and are completely reliant upon the fiction of paper water entitlements. Neither new pipes nor old paper has ever produced an additional water resource for the state of California. Common sense, however, and the law of political expediency would indicate that a multi-billion-dollar capital facilities pipeline will not be built to remain empty. Sooner or later, water from the Delta to fill those tunnels will be taken from the least politically powerful sources with the least power to resist: the water-dependent public trust resources of the Delta and the fisheries and in Delta water rights holders and communities that depend upon those resources. They will be deemed expendable in the face of the massive demand of water from users south of the Delta who are obligated to pay for the otherwise empty pipes. This is the unstated ultimate consequence of the failure to establish specific, dedicated, in-Delta water flows and designated water supplies identified expressly to preserve and protect public trust resources and Delta water quality before billions of California taxpayers' dollars are spent on pipes with no water to fill them. One would be challenged to identify a project that is less consistent with the public interest than the WaterFix. Finally, petitioners' proposal to use the legislatively undefined concept of adaptive management to disguise or simply wish away significant deficiencies in the WaterFix proposal renders the project as proposed untenable. My personal experience with adaptive management in a variety of venues is that the lack of consistent decision-making by staff because of consistent turnovers of staff and the consistent, oftentimes, reinterpretation of mandates and policies by ever-changing bureaucrats, and the lack of sustained funding, which is often forgotten after a decision is made, and the lack of enforceable penalties virtually guarantee failure. I referenced the National Resource Council review of the Bay Delta Conservation Plan in my testimony. That's the predecessor to the WaterFix, and prepared a report titled, they prepared a report titled Review and Use of Science and Adaptive Management in the California draft Bay Delta Conservation Plan. They observed, and I personally agree based on my personal experience, that...
Hold on, please.
Yes, ma'am.
Attention all building occupants. Attention all building occupants. A fire alarm sounded on floors 20, 21, 22. The floors that were in alarm are all clear. Please return to your designated work areas. I repeat. Attention all building occupants. Attention all building occupants. A fire alarm sounded on floors 20, 21, 22. The floors that were in alarm are all clear. Please return to your designated work areas. Thank you.
Let's enjoy this moment of silence. No alarms. Mr. Del Piero, please continue.
Thank you. Despite the numerous attempts to silence me, pardon me, Madam Chair, I apologize. Despite the numerous attempts to develop and implement the adaptive environmental management strategies, many of them have not been successful, and I've referenced, rather than go on in regards to that, I've referenced that specifically in my written testimony submitted to the board. I think it's appropriate for me at this point to leave the board members with certain thoughts in conclusion. The reasonableness doctrine and the public trust are not going away. They just haven't been satisfied, nor have the demands upon the state board been met when you compare those to other uses and to the need for the state board to recognize changes in conditions. There have been massive changes in conditions since the original permits for the state project and the Central Valley project were issued. And the board needs to understand and take those into consideration when it proceeds to set public trust flow requirements during the process that you're now involved in. Justice Racanelli said that the state has a duty to take public trust into account whenever feasible. That's an exact quote out of the decision. Madam Chair and members of the board, it's feasible now. Contrary to the petitioner's characterizations, the proposed petition is not a minor change. It's a massive project as defined by CEQA that will have huge and numerous significant adverse environmental impacts upon protected public trust resources and upon environmental resources in general. The petitioners would have this board believe that adding 9,000 cubic feet per second of diversion capacity to the northern delta, some 35 to 40 miles away from the petitioner's existing diversions, is somehow a minor change. As presented in the cases in chief of various protestants, this change would have an existential effect on water users and the beneficial uses in the delta and devastate what's left of the public trust. One last thought, Madam Chair, and then I'll subject myself to whatever questions anyone might have. The State Water Resources Control Board is a responsible agency in the CEQA process. I've indicated in my testimony that a water availability analysis, I believe, is necessary for you to satisfy your public trust duties. It is also under my reading of the law, appropriate, if not necessary, but appropriate for the state board to demand of lead agencies preparing environmental documents to incorporate into those environmental documents an evaluation of those environmental issues that the state board believes it's necessary to have so that the board can render an intelligent, thoughtful, and legally sustainable decision in its capacity as a responsible agency. So asking for a water availability analysis in order to meet your requirements as the responsible agency is not inappropriate and is fully within your authority. Madam Chair, that concludes my comments. Thank you very much.
Thank you, Mr. Del Piero. Mr. Mizell.
Yes, I'd like to object to the last statement, and as far as it goes to addressing a CEQA concern, he is indicating that he doesn't believe that the CEQA document is sufficient and should include additional analyses under a legal theory that he has. So I would move to strike that as being already ruled upon by you as being outside the scope of this hearing, as it challenges the CEQA document.
I believe he framed his testimony in terms of our responsibility as a responsible agency in considering the CEQA document for our purposes in this hearing. That was my understanding, Mr. Piero, correct?
That is correct, Madam Chair.
Does anyone else want to respond to that objection?
You have it.
Overruled, Mr. Mizell. Anything else?
Thank you, Mr. Del Piero. No, our witnesses are available for cross-examination.
Any cross? Mr. Ruiz?
Yes, I have some cross from Mr. Del Piero. I think it's probably 20 to 30 minutes, the outside.
Right. Mr. Mizell, the department had indicated yesterday that you did not have any cross, but you do have objections to lodge. Why don't you go ahead and lodge those objections now, or at least a summary of them?
Yes, I can either address them all, or if you'd like, I can go over the topics and we can file them in writing.
Why don't we go over the topic first?
Certainly, we have additional objections to testimony we believe still falls within the challenging of a CEQA process, which has previously been ruled beyond the scope of this hearing. We also have objections relating to testimony we believe addresses key hearing issues of Part 1 and not Part 2, and therefore should be stricken. We have hearsay objections. We also have objections as to the value of certain aspects of the testimony as not being that which a reasonable person would rely upon in this context. We also have objections to, well, this one's when they go to admit their evidence into the record. Those are the main categories.
And how extensive and detailed are those objections? Ms. Ainsley had indicated yesterday that they were detailed enough that she requested that they be submitted in writing.
Yes, I have 4 pages of rather detailed notes. I can either go through the passages and explain the objections now, or we can file them in writing. Your preference.
Ms. Meserve?
I guess one thing I would note is that the witness is available here today, and if there are any issues with the, for instance, on the reasonable reliance or the basis of his testimony, I think it would be most appropriate for DWR to simply ask the witness those questions while he's here to test their theories. But with respect to whatever other objections there are, we have no problem with responding in writing, and that may be more efficient of everyone's time.
Response, Mr. Mizell?
Yeah, these objections are not something that could be cured by questioning of the witness.
All right. Mr. Mizell, you may have until noon tomorrow to file your written objections. And Ms. Meserve, Mr. Keeling, Mr. Jackson, you may have until noon, Friday? Is tomorrow Thursday? Yes, noon Friday to respond.
I would just say if there Apparently DWR has been working on this for a while, so I guess I would request until Monday noon if they're as voluminous as Mr. Mizell seems to be indicating.
Monday noon. With that, Mr. Ruiz, please come up and conduct your cross.
Good morning, Mr. Del Piero.
Good morning.
I'm Dean Reese, and I'm here on behalf of the South Delta Water Agency parties, and I have some questions for you that fall into three basic categories. Your testimony with regard to lack of a water availability analysis, the balancing of the public trust, and adaptive management generally. Your testimony squarely focuses on the lack of water availability analysis. And on page 8 of your testimony, you write that there is not currently enough water available in the Delta to sustain the public trust resources of the Delta. And I've heard you testify just a moment ago about you feel that the board has the discretion, the authority to require a water availability analysis. But I want to understand as clearly as possible why you think a water availability analysis is essential before petitioners' request for a point and change of diversion can be decided upon.
Well, a water availability analysis is required because the state legislature has embodied that requirement in the statutes. A water availability analysis is required because the Audubon Court and Judge Raganelli told us we needed to do it. And a water availability analysis is required because of the board's ongoing obligations to continue to monitor and adjust and protections for the public trust resources in the Delta. And absent a water availability analysis, the board can't exercise its constitutional as well as its statutory duties.
And turning your attention to page 8 of your testimony, you state that petitioners are wrongfully relying on ancient water rights that are nothing more than worthless paper water rights. What do you mean by that specifically?
If one reviews the water rights that the petitioners have introduced into the record as part of the California WaterFix proposals, and when I say proposals, it's because it changes a lot, so it's sort of hard to keep a track of exactly what it is they're proposing due to a lack of specificity. The one thing I can tell you is that the magnitude of the water that was allowed as part of those original permits issued before by the state Water Rights Board and by the state engineer far exceed what the last 70 years of hydrology are able to demonstrate. Except in the very wettest of years when there's a lack of storage capacity and frankly a lack of demand. The hydrologic records demonstrate that the water that was granted as part of those permits just doesn't exist, probably never has. And so a multi-billion-dollar pipeline project that by their own admission doesn't generate any new water. It only supposedly improves reliability. Has to be predicated upon something. And if it's only 9,000 cubic feet per second, there's no cost-benefit analysis that I'm aware of that anyone could produce that could demonstrate that there's any water left in that system. Moreover, everyone needs to just face up to the reality that the public trust resources and the ecological health of the Delta is in effective free fall, if not collapsed. You can't take a look at the trawl studies done by the California Department of Fish and Wildlife for the better part of the last 40 years and recognize continuing declines in both endangered as well as threatened species, both pelagic as well as anadromous fisheries in the Delta without recognizing that there's a problem. And the problem is real simple. You can throw as much money at the Delta as you want until there is water available for the protection of public trust resources, until more water is committed by the state board and the state to the protection and preservation of public trust resources, then continuing to rely on old paper and new pipes isn't going to fix the problem.
Before you continue, Mr. Ruiz, Mr. Mizell, did you have an objection to lodge? I saw you standing earlier by the microphone.
Yes, it's a bit past at this point, but Department objects to commingling of Part 1 issues again. Whether or not this petition requires a new water right was a key hearing issue in Part 1 and not in Part 2. Now, I understand that Mr. Del Piero is trying to tie it to the public trust and the public interest. However, I don't believe that the public trust and public interest should be used as a panacea for all complaints that were encompassed within Part 1. There's an effective avenue for that, which is rebuttal, and he can address those issues on CSPA's or San Joaquin County's rebuttal testimony. But challenging the need for a new water right in his case in chief is inappropriate, and I'd object to the question is bringing out points that are more appropriate for later.
Mr. Ruiz?
I would point out that the question of water availability analysis and paper water was struck from his Part 1 testimony, and that's why it's in Part 2. It was a public trust issue. So which part are we talking about?
All right. Overrule, Mr. Mizell.
Mr. Del Piero, you've testified that the project proponents have failed to balance the public trust. What, in your opinion, are the essential steps required for a balancing of the public trust?
Well, an acknowledgement that you've got a duty to something called a public trust in the first place wouldn't hurt. The fact that the operations of the projects over the better part of the last 5 decades have been conducted in such a fashion as to continue to watch the decline in environmental resources without the operators taking it upon themselves to do the right thing is probably indicative of the fact that they lack any appreciation or obligation or sense of obligation, if you will, that the protection of the public trust is the responsibility of any other public agency other than the State Water Resources Control Board. I don't believe that to be the case. I believe the State Department of Water Resources bears a huge burden in its responsibilities to operate those projects in order to protect the public trust resources of the state. If not, the preeminent responsibility that they have in the operation of those projects is to protect the public trust resources of the state before they guarantee water to their customers. And so in order to initiate a program of dealing with that, not only do you need to have an acknowledgement that there's been a problem, and you also need to lay out a systematic method by which you, one, quantify the water availability that exists, wet water, not paper, wet water that exists. And then you identify the water requirements for public trust resources that haven't been required since long before the water, well, they weren't required at the time the permits were issued in the first place, so they've never been required. So you quantify the amount of water that's necessary in order to protect and preserve whatever the baseline is that you decide to establish for your public trust resources. And then you go to riparian users and senior water rights holders, and then you go to the Central Valley Project and the State Water Project. And if, after you've made all of those incremental decisions predicated upon actual evidence, not trust me, then you might get to the point of discovering exactly how much water, if any, would ever be generated or allowed to pass through the proposed California WaterFix. But this is not rocket science. There are massive numbers of engineers that have been employed by the state of California for the better part of 5 decades. I'm not aware that any of them have ever initiated this process. And so continuing to point the finger at the state board and say, well, you know, this is a state board problem, when the duty for the protection of the public trust resources of this state fall on the shoulders of every bureaucrat, every senior executive of every major institution that provides services to the residents of the state of California. That's what we're here talking about. It's not whether or not the state board has satisfied its obligations. We know the state board hasn't satisfied its obligation. That doesn't mean the obligation is unique. The Department of Water Resources is a failure. So is the Central Valley Project. And I say that recognizing that if the Delta ecosystem and the public trust resources upon which all of us rely and benefit had not collapsed, then I wouldn't make a mean-sounding statement like that, but that's not the case. They watched it collapse and let it go.
Thank you. Mr. Del Piero, do you believe there is any way possible to achieve a balancing of the public trust in the context of this petition without first conducting an actual water availability analysis?
No.
Del Piero, you are aware of the fact that petitioners have assured the board, this board, that California WaterFix will comply with Decision D-1641 and any other legal requirements governing the project's operations in the Delta?
I'm aware that they made that promise. At least I've read it in the newspapers.
What, in your opinion, is problematic or insufficient about that assurance with respect to protecting the resources of the Delta?
It's probably, in all sincerity, there used to be a president of the United States that had a fondness for saying trust but verify. I served on this board for 8 years, and I heard the same representations from the department and the Central Valley Project. Trust me isn't working, hasn't worked in the last 30 years. I think the current board members have a duty and an obligation to incorporate measurable standards with really, really tough financial penalties for failure. Because at this point in time, given the decimated condition of the public trust resources in the Delta, unless you are just hard-nosed, there will be a continuing ignoring, if you will, of the duties of the protection of the public trust, to the point where sooner or later the Delta will just become a freshwater estuary that's used as part of the plumbing for the delivery of water someplace else.
At pages 3 and 4 of your written testimony, you write that in 1992 and 1993, while I was serving on the State Water Resources Control Board, we came very close to adopting a water rights decision, which was Draft Decision 1630, that would have addressed many, if not all, of those desired outcomes for the Delta today. How would Draft Decision 1630, if implemented, how would that have occurred? How would that have accomplished those goals?
D-1630, a little background, if you will. D-1630 was drafted my first year that I was on the State Water Resources Control Board. Members of the State Water Board at that time were the Chairman Don Mon, Eliseo Samaniego, John Caffrey, and me. Ted Finster rotated off within the first couple of months, and it was he was subsequently replaced with a representative from Santa Barbara County. The preparation of 1630 was the ultimate culmination of the board's efforts to try and implement the Racanelli decision of 6 or 7 years earlier. And Justice Racanelli was very clear because Justice Racanelli's decision was predicated upon the Audubon decision from 1983. So 1630 did its very best to have specific, measurable standards, flow standards, water quality standards, locations for water quality goals to be met, a whole variety of measurable, enforceable requirements. Unfortunately, I'm going to tell you a story. I apologize, Madam Chair. When the draft was completed, Don Maughan, the chair, was very ill. And he knew he was not going to make it through the hearing process. And so that brought the board down to only 4 members. We set the hearing, we set the matter for hearing, and a copy of the draft was circulated. At the time, part of being a board member as the chair and board member Diadamo knows is counting to 3. It's a skill you need to have when you sit on a 5-member board. And so when there were 3 votes at the time to approve 1630, Sam Samaniego, Don Maughan, and Mark Del Piero. When Don's health effectively collapsed, and he passed away not long after that, he left the board, and it left us with 4 members. And I was sitting in my office one day, and I'm sure someone's going to object to this as hearsay, but I will tell you the story anyway, so you understand the background. Sam Samaniego came into my office.
Del Piero, I'm sorry. I appreciate the background, having actually been on the board staff during that time. But I'm curious, Mr. Ruiz's question was more specific to not the background of what happened with the draft decision 1630, but as I understand it, Mr. Ruiz, how the proposal in that draft decision would have provided the protection that Mr. Del Piero mentioned in his testimony.
That's correct. That was my question. However, my next question was going to be, what was the fate of that draft decision?
You anticipated, Mr. Ruiz.
I did not anticipate it, and Mr. Ruiz and I don't think we've ever even met before, so
All right, so please continue, but
Okay. Please
do not forget to go back to the substance of
Yes, ma'am.
draft decision 1630 to address Mr. Ruiz's initial question.
Yes, ma'am. Don had to retire because of his health, left 4 members on the board. I was sitting in my office about 2 weeks, maybe 3 weeks before the next hearing was scheduled, and Sam came in, walked in, this is the old Bonderson building, shut the door, sat down in front of me, and he said, I got a phone call. And I said, really? And he was looking very grim. And he said, yeah. He said, I can get reappointed to the board so long as I vote against 1630. And I asked him who the phone call was from, and he told me, and it was clear that that phone call was direction. He was because he was up for reappointment. And I said, well, what are you going to do? What'd you tell him? And he said, I was going to vote for 1630. And he was promptly not reappointed to the state board, which left 3 board members. And if you can't count to 3, or when you only have 3 board members, you don't get a decision that was approved. And so D 1630, the draft, still shows up on the website for the State Water Resources Control Board, but it did not get adopted.
Thank you.
Now, the reason it didn't get adopted is because it implemented, succinctly, Madam Chair, it implemented Racanelli. It implemented Audubon. It implemented all of those things that individuals who some of whom have been part of the petitioners group here object to. And I think you heard it again today when you heard objections to whether or not the public trust and the application of protection policies and provisions for the public trust is appropriate for this board to consider as part of this hearing process.
Thank you.
Before you continue, Mr. Rees, Mr. Mizell.
Yes, as Mr. Del Piero anticipated, I'm lodging a hearsay objection on that answer.
So noted.
Mr. Del Piero, on page 5 of your testimony, you write that the August 3rd, 2010 SWRCB final report on delta flow criteria calls out the necessity of increasing real wet water flows into the delta to save its constitutionally protected public trust fisheries. My question is it your opinion that if the CWF project is approved, should it at a minimum be conditioned upon compliance with the increased real wet water flows into the delta as set forth in the 2010 final report on the delta flow criteria?
Yes. And I might add, I actually thought the delta flow criteria report from 2010 was pretty good project, or pretty good document, given what the board had to work with, given that the previous decisions of the board were not as strong in terms of protection of the public the public trust resources as I would have expected. I thought 2010 was really, frankly, pretty good work. But it's really pretty good work that is going to be for naught, because it's 8 years after the fact, and unless those findings and recommendations are reduced to enforceable mandates to be incorporated into the obligations of the petitioners as part of this project, it's just going to be one more thing that was reduced to writing that didn't, with all good intentions, didn't save the delta.
Thank you. At page 7 of your testimony, you observe that the fishery agencies are not participating in this proceeding. Does that concern you?
Well, I could give you a cheeky answer and say, since there are virtually no fish left in the delta, there's no surprise that they aren't here. But that's again a cheeky answer. The fact of the matter is the absence of the fisheries agencies, I think, significantly undercuts the ability of the state board to do its job in terms of balancing obligations and protections of public trust resources. And I'm not sure why they aren't here, but I don't think they're doing anybody any favors, because sooner or later, either you're going to accept the extinction of all those species that are currently listed as either, as listed as threatened or endangered, or you're going to have to deal with the fact that increased flows into the delta are the only way to address, protect, and maybe even just save what remaining public trust resources there are.
Mr. Del Piero, on page 26 and 27 of your testimony, you discuss petitioners' reliance on the concept of adaptive management. At page 26, at line 16, you say that adaptive management is a legislatively undefined concept. I have two questions related to that. What specifically do you mean by that, and why is that significant?
I've looked everywhere. I can't find anywhere where adaptive management has been defined by the state legislature. I can't find it. So when a judge goes to try and figure out what this board means, if it adopts something as speculative, or if not amorphous as adaptive management, a judge is going to say, I can't render a decision as to whether or not this was achieved, because there's no measurable standards by which to judge it. So adaptive management is meaningless at this point, If you can't, if you don't, if the petitioners want, if the petitioners want adaptive management, they should have made a presentation to this board as to what adaptive management meant. What meaningful, substantive, and enforceable criteria constitutes adaptive management, so that the chair and the other members of this board can incorporate those into enforceable terms and conditions into whatever permits they decide to issue.
Are you aware of an adaptive management, based on your experience, anywhere near the scope of this project that's ever been successfully implemented?
No, and I'm also aware of a bunch of adaptive management programs around the state dealing with a variety of issues and a variety of environmental issues that are much smaller than this, that have been abject failures. So adaptive management is generally used, and please keep in mind, during the course of my career, I've been responsible for over 150 environmental impact reports, either voting in favor of them or voting against them. And I've litigated a number of CEQA cases during the course of my career and written a lot of land use policies and regulations. The situation you have here is absent measurable standards. Adaptive management is not only not enforceable, it's impossible to define. I can, and if you want an example of something unrelated to water issues, I'll be happy to give you an example of the Elkhorn Slough National Estuarine Research Reserve that was predicated upon adaptive management. And that reserve, which started off as a brackish water reserve in 1978, is now a seawater estuary. There's been loss of probably 80% of the fresh and brackish water habitat, as well as species in that, all predicated upon the idea that members of the Coastal Commission were going to use adaptive management in terms of restoration of that program. And there was no penalty. There has been no penalty. I guess that's one last thing I might want to point out in regards to adaptive management. Who's a responsible party? Who gets fired if they fail? Who loses their job? Who gets a note in their personnel file saying this was the dumbest thing anybody ever came up with and this person should never be promoted ever again? You have no mechanism by which you're judging anything in regards to adaptive management or attributing fault when it fails. They have to be responsible for enforcing specific terms and conditions to protect the public resources of the Delta.
Similarly, related to the same topic, at page 27, you write that reliance on the proposed adaptive management would constitute a wrongful delegation of the board's constitutional duties and powers. What specifically do you mean by that?
Audubon said that the board had an ongoing duty and responsibility to monitor and perform its responsibilities to protect, preserve the public trust resources of the state of California, specifically in the case of Mono Lake, but it's equally applicable everywhere to all the waters of the state. Racanelli said the same thing in regards to the Delta and water quality. Delegating the board's responsibility for its ongoing monitoring, protection, and preservation of the public trust resources to a nameless, faceless group of bureaucrats on the premise of something called adaptive management, which the state legislature nor any court has ever defined, is an abdication of the State Water Resources Control Board's constitutional and legal duties to do its job. Real simple.
Thank you.
And one last comment, delegating it to the Department of Water Resources and to the Central Valley Project, who have had a history of failing to address the needs of the public trust resources of the Delta, is sort of just pretty foolish.
How much more do you have, Mr. Ruiz?
I just have actually 3 questions.
All right, and Mr. Mizell, do you have an objection?
It was simply an inquiry, and question more than an objection, as much as I'm sure the attorneys from San Joaquin County Land and Central Delta, South Delta Water Agency enjoy open-ended friendly cross. I do have to question the probative value of asking an open-ended question for him to expand upon his written testimony and then bring in examples that are nowhere in that written testimony. It strikes me as borderline surprise testimony at this point. It would be nice if the questions were concise and the answers address the question specifically, rather than introducing long narrative answers that go well beyond the question as well beyond the testimony.
I might look to my counsel for confirmation, but I don't believe there is any such thing as surprise testimony during cross.
That is correct. And during cross-examination, testimony or questions can touch on any Part 2 issue.
Overruled. And Mr. Ruiz, another 5-10 minutes?
Yes.
Madam Chair, could you hold on for 1 second? The throat's starting to bug me a little bit.
Okay,
Excuse me
well,
for
we'll
just a second.
try to keep it short.
There's 2 questions then.
No, I'm okay. Let's go.
Sure?
Yes, sir.
Okay.
Let's go.
At page 24 and 25 of your testimony, you say that in this proceeding under section 1701 and 1702 of the Water Code, petitioners cannot meet their public trust obligations by relying on mitigation measures that purportedly reduce impacts to less than significant levels. Why is that, in your opinion, that they
Because
cannot rely on those?
Because the code doesn't allow that standard. That's a standard out of CEQA. You have a no harm obligation under 1702. No injury is allowed to be perpetrated upon any senior or prior user of legal user of water, and 1702 embodies that. The requirement to or the reference to reducing something to a less than significant adverse effect is a reference out of the California Environmental Quality Act. There's no equivalency between the obligation of the State Water Resources Control Board vis-a-vis Section 1702 of the Water Code and the provisions of CEQA that allow for mitigation of significant adverse impacts. Moreover, CEQA doesn't even obligate the lead agency or the petitioners to actually implement any kind of mitigation. They can just make a finding of overriding consideration and walk away from it. So it's clear that they're mixing apples and oranges. Those 2 standards don't have any equivalency at all.
Thank you. Last question. On page 19, you refer to the Racanelli decision with respect to its findings that the state board has 2 primary duties in its role in issuing appropriated permits. 1, to determine if surplus water is available, and 2, to protect the public interest. Has anything occurred in your view since the Racanelli decision that changes those 2 primary duties?
Nothing.
Thank you. I have no further questions.
Thank you, Mr. Ruiz. Any redirect?
No redirect.
All right, thank you. Let me take this opportunity now to make a correction. Apparently, I erred earlier, my only one error allowed during this proceeding. I am advised that this is in response to Mr. Meisel's objection to Mr. Del Piero's testimony regarding the water availability analysis. Apparently, in our April 13th, 2017 ruling, we did strike Mr. Del Piero's testimony concerning the requirement of a WAA as being outside the scope of the hearing, not just the scope of Part 1, but the scope of the hearing. So on that ground, I will reverse my overruling of Mr. Meisel's objection, and that portion of Mr. Del Piero's testimony is struck.
That portion being what exactly?
Recommendation of a WAA and testimony concerning that as part of these proceedings.
As part of his analysis of the public trust obligations.
Correct. Mr. Mizell?
Yes, if it would assist the board, there were also cross-examination answers given and questions asked along those lines. I would like to brief those in the objections that we file.
Please
I
do.
might have until the end of tomorrow then in order to get the transcripts that will be available tonight and provide you with citations.
All right. So you will file your objections by 5 p.m. tomorrow.
Correct.
And protestants will still have until noon Monday to respond.
Yes, I mean, I would just say Mr. Del Piero's opinions regarding the need for water availability analysis have come up both in part 1 and part 2, and it's I think, yeah, I would like to deal with that in briefing rather than just, it would take out a tremendous amount of his testimony if you were to say that that same ruling from over a year ago applies to everything here today. And I also would note that the board did strike out some portions of Mr. Del Piero's testimony in January of this year and did leave in certain points regarding the value and need for water availability analysis. So I just would hope not to prejudge that and let that play out in the briefing.
And I would add that...
Go ahead. Mr. Mizell will submit his objections again in writing. Ms. Meserve, you may respond to that in writing. I would ask you to look at our April 13th, 2017 ruling, reference that, and make your arguments based on that ruling.
And I would just add that, so the portions of testimony, whether Mr. Del Piero's or anyone else's that were struck during the hearing team's review for scope, those were not definitive statements of these are the only things that are beyond the scope. That was the hearing team's first pass. And so other parties are still free to argue that thing, and this goes not just to Mr. Del Piero's testimony, but it extends to everyone. They're still free to argue that certain matters are within or not within the scope.
As a point of clarification, since Racanelli made it very clear that in a public trust sense, water availability analysis was one of the board's first duties. It is different, I think, both factually and legally, from the ruling that it didn't apply to the 1702 kind of requirement. Those are two different things, and it seems that the ruling, which the hearing officer just sort of took as settled, is probably dicta, because it's a completely different set of factual analysis between 1701 or the 1700 section and the duty under the public trust to determine that there's water available.
Right. I will look forward to reading all your arguments on that particular set of objections. All right.
Now that is Mr. Del Piero is the last witness for the San Joaquin County protestants, and we do request that all of the exhibits submitted in support of our case in chief be admitted into evidence, and we will have a list and update the list. Well, I'll send a letter to the hearing officers. I would like a point of clarification. There have been varying practices, and I know you've said this before. And with respect to exhibits used on cross, my understanding is we don't need to list exhibits that have already been admitted by some party.
That's correct.
That we've used in cross, and the only things we need to update on our exhibit list are cross-examination exhibits that were not already admitted in connection with somebody's testimony.
And if I remember Ms. How easy I forget the name, Ms. Heinrichs, I guess, legal opinion from part 1 was that you don't even have to submit cross-examination exhibits into the record. Now that I have a new attorney, maybe that's changed. I hope not. But Mr. Keeling I will address deadlines for cross-examination exhibits shortly.
Thank you.
At this time, before we move on to other parties, Mr. Keeling has moved exhibits for San Joaquin County. Are there any objections?
Yes, we have one objection to San Joaquin County Exhibit 286. This is the Tunnel Talk website. It's a website and not a document, therefore it's not static. It's continuing to evolve as new posts are placed. It is therefore not what a reasonable person would rely upon because it can't be counted upon to contain the same information from day to day. In addition, we would object to that as being hearsay, as it consists entirely of blog posts of its author and not of documents and facts that can be verified. It's merely opinion. So again, under Government Code 11513, we would object to San Joaquin County 286.
Your response, Mr. Keeling.
SJC 286 submitted as a PDF is not changing. The website may be changing, like this project, but as a snapshot in time as to what's there, I don't see what the problem is.
So that leaves you with a hearsay objection.
And that goes to wait.
Hearsay objection to the static PDF version. Oftentimes in the testimony, they would reference the exhibit followed by the website. So the website, any reliance on the website, we would object as being not static and continuing to evolve. The PDF version is simply a hearsay objection.
Mr. Keeling will use, what is the legal terminology? Agree, stipulate that any references to written testimony to the website is actually a reference to the PDF version that was submitted.
So stipulated.
All right, so that leaves then a hearsay objection to be noted. And otherwise, your exhibits are received into the record, Mr. Keeling. Next.
And yes, in addition, local agencies of the North Delta is completed with its case in chief now. And so we would move that all of the exhibits from our various panels and the shared testimony that you heard here today and previously would be admitted into the record, and we will update our exhibit index if necessary, although I'm not sure it's necessary at this time, and we'd like to move everything into the record.
Objections to Leanne's exhibits? Seeing none, they have been so moved into the record, received, entered into the record. Mr. Jackson.
Yes, at this point, CSBA, CWIN, and Aqua Alliance's case in chiefs for Part 2 are complete, and I would like to move all of the exhibits identified on the exhibit identification list into evidence in Part 2 of the hearing. It's an extremely long list, and I'd prefer not to read it. Thank you.
Any objections?
I don't believe I have any objections. I have one request for clarification based on our earlier conversation on the citation.
Excuse me, I made an error in regard to CWIN's testimony. We withdrew yesterday. I think it was 207
7 and 208.
208.
So those would be, so the discussions we had yesterday would still apply to what
Yes.
you're submitting in.
I just wanted to make sure that it didn't happen inadvertently.
Thank you.
And with that, your request is granted, and CWIN, C-SPA, and Aqua Alliance exhibits are moved into the record.
Thank you.
Thank you, Mr. Smith and Mr. Del Piero. And thank you, Mr. Keeling, Ms. Meserve, Mr. Jackson, and actually all the attorneys and all the witnesses who have appeared for case in chief during Part 2. I appreciate the tremendous effort everyone has put into this. It's been a challenging task to organize witnesses and panels and get testimony in place. And the fact that we have moved so efficiently and effectively would not have happened without all of your tremendous effort. I greatly appreciate that and just want to acknowledge it. Let's give you a few deadlines. And I'm glad Ms. Tabor is here for this. You have until noon this Friday, April 27th, to move cross-examination exhibits into the record. And you have until noon Tuesday, May 1st, to file any objections to those cross-examination exhibits. And you have until noon Friday, May 4th, to respond to those objections. Ms. Meserve, there is an outstanding issue with respect to Snug Harbor and exhibits for Snug Harbor. I believe you had made a request that you were trying to work out with Ms. Ainsley some objections regarding Ms. Seward's exhibits, and you wanted to wait until cross-examination are completed so that you could submit all of her exhibits. Your deadline then is also noon Friday, April 27th, to move Snug Harbor's exhibits into the record.
Yes, and I see actually that Ms. Seward has sent an email this morning with her exhibits, so I believe she should be all done.
All right, she beat me to it.
And would the May 1st deadline then apply to any further objection that might, and we don't anticipate there being any, but if
Yes.
there are any, okay.
To Ms. Seward's exhibits. We will need some time to review all that will be submitted with respect to cross-examination exhibits. There might even be a few outstanding motion that we need to rule on. So we will issue a ruling forthcoming that will address all those outstanding issues, as well as directions, guidelines, and a schedule for rebuttal. And the hearing will resume in accordance with that forthcoming ruling.
I would just like to make a brief comment with respect to the schedule for rebuttal. And maybe once we see the ruling, we could respond to it. But I would just hesitate, to, given some of the ambiguities around what all information will be included in the supplemental EIR that DWR is working on, I would be hesitant to try to set a set schedule because we don't know the content of that, and we won't until at least the time the draft is released. So I would suggest it may be appropriate to revisit schedule at that time when we know what all, we've heard certain representations about what will be in there, and we have a very brief fact sheet that is not very clear about what the changes are. So I would just suggest it may be something to check back in on before a schedule would be set.
I understand those concerns. We actually have had a discussion about that earlier this week. All the hearing dates run together in my mind. And certainly those are things that we are still considering, which is why it will take at least a few weeks before we issue a ruling with any specificity regarding rebuttal. Mr. Mizell, anything to add?
Not on this issue, no.
Right. If there isn't anything else, I will once again thank all of you, all the parties. Oh, Mr. Jackson.
Yes, I was just remembering how useful some of your pre-hearing conferences have been, and it might be very useful to set a date after you do your ruling or in your ruling for a pre-hearing conference about rebuttal, so that we could get the advice of all of the parties who are not here today.
We will take that into consideration. Mr. Mizell.
Yes, before Mr. Jackson and his group leave the stand, I do have one objection for the record and then one request for a clarification.
And what is your objection? I thought we had closed the door on objections, at least to exhibits.
This is not an objection to the exhibit being admitted into the record. This is a hearsay objection for the record on CSPA 400, 401, 402, and 403. So that would not have prohibited them from being admitted into the record. This is just for purposes of clarity in the record.
Okay, so noted.
And the question is, earlier we were talking about Dr. Budgore's citation, and Mr. Jackson provided us with Appendix 5 to the Santa Barbara report. The appendices are not numeric, they're alphabetic, and so we looked at Appendix E, which would be the 5th appendix, and we were unable to find any information in that appendix related to the question at hand. So my question would be, either is there a different appendix, or are we clear at this time that the only evidence for the statement by Dr. Budgor is his personal experience?
Yes, supporting the hearsay statements that that he received from each of the water agencies that he listed. Hearsay can be admitted when it's supported by other evidence.
All right. We so noted. Again, thank you to everyone. Thank you to the court reporters and all the staff. And with that, we are adjourned.